took your kids. They broke the law. Now it's time to even the score. Hey. CPS came knocking, badges flashing lies for your family apart under fluorescent skies. But shadows got a skull now, AI locked and loaded. Scan your docs, expose the fraud, watch the tyrants get demoted. Violations stacked like bodies in the street. Constitutional rights they tried to delete. Upload the evidence, let the algorithm strike. We don't beg for mercy, we punish what ain't right. CPS, Punisher, mount up, skull on the app. Justice won't stop, fight back harder, never gonna drop. Punisher rising, your family's on top. CPS, Punisher, lock and load, break the chains, reclaim the road. AI warrior, truth overload. They fear the skull, cause the Punisher's code. Family court circus, judges playing God, but we got the blueprint. Beat them at their fraud, step by step defense, no more silent screams. Turn their violations into criminal schemes. From Hampton streets to every county line, parents unite, it's payback time. That's Punisher.com, download the fire, turn pain to power, set the system on fire. They thought we were broken, they thought wrong. AI in your corner, vengeance prolonged. No retreat, no surrender, no compromise. The skull don't blink when justice arrives. CPS, Punisher, Punisher. We don't ask, we deliver the thunder. Punisher, Punisher. Family forever, tyrants go under. Punisher rising, the war's just begun. Download now, your fight's already won. The CPS Punisher, justice served cold. Protect what's yours, stand tall, fight on. Fight on. Yo, this is for the fighters on Equal and the Same. Stand tall, America. Rights ain't a game. 80 strong. CPS down. Let's ignite the flame. Born in the land of the free, hardcore to the bone. Eagle on my chest, Constitution my throne. From the back roads of freedom to the city lights bright. I stand on my rights, day and night, ready to fight. Government overreach, nah, I draw the line. Bill of Rights, all my Second Amendment shine. Data warriors, breaking barriers down. Disability rights, wear that crown. No ramps, no access, we rise and we roar. Equal under law, demanding more. Hardcore American, fist to the sky, fist to the sky. Stand on your rights, stand on your rights. Never comply, never comply. Support the ADA, hey, hey, hey. Let freedom reign, freedom reign. Abolish CPS, abolish CPS. Clip their wings, equal and the same. Punch got truth, we claim. United, we stand in liberty's name. In liberty's name. Whoa. Rights forever. Whoa. CPS never. CPS storming in, tearing families apart. False claims and power plays, breaking every heart. Kids ripped from homes, no due process in sight. We abolitionists rally, turn wrong into right. From the farm to the courts, we expose the lies. Parental rights sacred under American skies. They a backbone for the blind, deaf, and bold. No discrimination, stories untold. Wheelchair rebels, mental health nights. We grind through the system, igniting the fight. Hardcore American, fist to the sky. Stand on your rights, stand on your rights. Never comply, never comply. Support the ADA.
Well, hello, everyone. Welcome to Equal and the Same. It's Henry Martaccio here on 3/28/26. Unfortunate news. I still have another week to produce my document. I'm hoping now for this Monday's filing. on the federal court removal underneath the American Disabilities Act, non-compliancy of policies and procedures, and the administrative duties. Tonight, I'm hoping that we can take a little look into a few things. I'm going to give Darren some time. We loaded up quite a few documents that are going to explain a lot to everyone in my arguments, and I'm wishing somebody would engage, somebody would try to take me on these theories. Yes, it's all AI checked. That doesn't mean you have the right to just assume it's the truth. You're going to have to, educationally speaking, that's all we're here for. And what we really want to do is just, teach everyone or have an open community talk, because there was a time in this country where, our children would go to school and be taught of their constitutional rights. And that seems to happen no more. And what we find is that when you're in the state programs of program services and activities, that they're hiding the truth on how the operation should actually be working. And it's pretty sad, in my opinion, that we're dealing with people who have a prophylactic protection and a mandated strict scrutiny as part of their achievement of receiving federal funding. And I don't care if it's for a highway, a bridge, or disabled. The feds have pretty much ruled that, they give them so much money in regards in federal grants, education, all the way down to community, that, human disasters, that the state should actually have given the opportunity and affording the opportunity for these equal rights to the people with disabilities, or people who are perceived as having disabilities. Because, guys, again, when somebody's perceiving you, who are they qualified to even make the diagnose? Were they even qualified to make this inquiry without making it as a discriminatory claim? Because you just can't walk around saying that person's nuts, this person's nuts. If you're not appropriately trained and you cannot test your hypotheses to prove that your diagnosing skills are there, that's where you have to become affiliated to a hospital and get your own ongoing training and have clinical experience, the whole 9 yards. But yet family courts or CPS doesn't want to play that game. So how is this really medically necessary? If anything, it should be a violation of our medical rights, our HIPAA rights. And, that's where I'm standing as a person. So again, hi, everyone. Thank you for joining. Veronica and Kate. Surprised we don't have John here tonight. Where's my Canadian connection? So it's pretty sad what's going on in the world. We were hoping that this would all be wrapped up with the war that's going on, or whatever you want to call it. I call it saving our asses for the future. That's my personal opinion. We cannot have somebody that nuts to have a nuclear weapon. No different than we cannot have somebody who's known for domestic violence, or, hate with no cause of hating, if that makes sense. In other words, I just can't walk around and say I hate every black man in the world. I hate every Spanish dude in the world. You can't do that shit. It's wrong. There's pieces of shit in every race, gender. I don't care what it is. If you want to throw in the religion, hey, Tam, I'm glad you can join tonight. But we should have a real exciting news. And again, I'm not sure if he's got it up yet. At least the one document I can start on while we do the other one, because what we want to do is just give you the hyperlink, because you guys are not able to read along with me. And I know we won't be able to see everyone interacting, but maybe we can do a call-in hyperlink for somebody if they really have questions and they want to glance at it quick. That's it. I mean, we're going to make it a short, sweet, to the point night, and close out early, probably, or not. Depends on how it goes. If somebody wants to fire up the grill and let's get a good talk on, I'm all for it. Excuse me, I just slammed the sandwich. Again, it's just a crazy day, cranking out these documents. But where I seem to have a lot of problems with a lot of people is they don't understand their affirmative right to ask. They don't ask it. Hello, Tina. Thank you for joining. They have an affirmative obligation to be trained. When they're asked, they cannot ignore this asking. So, in my belief, is that as a state policy, their employees cannot purposely deflect the public, especially when it's a matter of a constitutional factor or a right of inquiry or a right to remedy a problem that you may be having. I don't care if it's local level or state level. A state employee or a town employee has to direct, has to get you, has an affirmative obligation to attempt to get you the answer you are seeking. The ADA is very clear about that. As a matter of fact, they have an affirmative responsibility where they must publish the names, addresses, and contact information. Your entitlement under the ADA is asked the job description. Make sure that you're dealing with the right person who has monetary control. I keep on saying this. In Rikers Island 2004 settlement agreement, you really need to pull down all the settlement agreements for your state. But again, where a problem I'm having is, people ain't getting this through their thick head. Once they ask and it goes unanswered, this is not like any other motion or any other right that when we file this, there's actually an affirmative obligation for the court clerks to do something. I don't care, because again, I believe it's under 107, 34, 38, USC 30. I'm all screwed. 35.107. It actually, I caught something today in my writings, and I asked it. It was, and it basically gave an affirmative responsibility, because at that point that you walk up to them, even though they're not the ADA contact person or the designated responsible employee, you've given them an appropriate notice that they must do something about as a state employee. They just cannot ignore it. It's not like your typical filings, guys. The authorities there, yes, they're going to deny. And that's what I'm trying to tell you. This is nothing new. They don't want to be compliant because it is going to hurt their system, their way of life. It's going to make it now where it's accountable in every step and action that they do in regards to a matter with somebody with a disability. And again, playing with it a little bit, I asked it, following with the 2019 settlement agreement of West Virginia and DOJ, it's basically a wraparound services. Can they remove a child from the home? And we were given that answer. No, not without an evaluation on how it impacts everybody. And again, sorry guys for the background tonight. I couldn't find something that's appropriate. I don't think you guys want to look at my unfinished basement, my war room, whatever you want to call it, ground zero, the whole 9 yards. But yeah, so that was the best background thing. But we right now it's 32 degrees out, so up here in Connecticut. So imagine that, how a pool was really going to affect me right now. I believe it or not, I think midweek they're going to have light snow showers up in Maine again. Just a typical spring in New England. We can't get the switch to turn on, and when it does turns on, it becomes 100 right away. It's full faucet. Where when we were kids, I remember spring, multiple days, beautiful, 60, 65 degree days, hot, warm sun on your back, perfect conditions. But yeah, so I don't know. Hey, Darren, did you get that one document up yet or no? Yeah, I'm in Connecticut, Tam, Hartford County. I'm where the capital is, which again, Tiff talked about the other night. Our capital is out of control, dude. We're not the constitutional state anymore. They're doing what they want. They removed the right for a state sheriff. They removed in 2000 Tano's argument to be able to be served by a grand jury instead of being on the paperwork and you not showing up to the grand jury to defend yourself. That was done, I believe, in 94. Don't quote me on it, but it was all in that era. But right now, what our governor is doing, we just had a No Kings rally today, which I kind of find hilarious. And again, they're out there chanting away their bullshit. not even understanding they're dealing with a system who, for 35 years, has been able to manipulate Congress's will and steal their funding because we have been Democrat majority ruled in the last 35 years. And that's pretty much when the constitutional state has gone downhill, in my opinion. Yeah, so I don't know. Yo, Darren, you backstage? Did you get her up? Did you get her done? Guess not. Maybe he had to go to the bathroom. Let's try doing it Henry's way then, because I'm all ready to show, and hopefully it shows the entire screen. I don't know if that's going to be possible or even how the hell do you even know. But so I asked the question. Now, if Congress said the states have to comply with and show compliancy at all times, is there any laws or regulations in regards to federal courts that we can ask the court to provide competency as a point of approval? Hey, you there?
Yeah, shoot, I put the wrong thing up there. I put our app up there. Sorry. It's right there. It's right damn next to me. Where the hell is it?
But in short answer, basically, yes, the federal law gives you a powerful argument that states must affirmatively demonstrate ADA / Title 504 or Title 4 compliancy. And federal courts have to repeatedly recognize the DOJ's authority to demand proof of compliancy. Guys, it ends it right there. So once you're getting screwed with, in my opinion, you have the right to do an immediate federal removal to ensure compliancy. I dig into the False Claims Act into this. I dig into a lot of stuff over this. Darren, can you even see that on your screen? Are they able to see any of this?
They are not looking at it just yet, Henry. I had it up there and then I took it down. I'm trying to squeeze it up there.
Oh, I'm saying for me, on my end, I'm sharing my screen.
No, your screen is not up there.
My screen is not up there. Again, back to this stupid ass problem.
No, because I just had this copy of it up here on.
Why? And it's saying right here, right now, restream, sharing your screen. Stop sharing. Hide. No, I want to share. So let's go back to it, guys. Sorry. This is half my problem in life. Everybody thinks technology. People like Darren, I look as having one hell of a gift. Having the ability to deal with the IT stuff. How about Windows? Let's try Windows. I see it now as a Windows doc. Now you should be able to see it, guys. Can you see that now? Yo, there.
Yo.
Can you see this?
Yes.
Okay, so basically, when I asked it, it gave me federal laws. DOJ has an exclusive authority to ensure state compliancy. And again, guys, this is what I'm asking the federal court is to refer it. I don't even want the federal judge to have the ability to deny or accept because I don't think he's got that right. If somebody's screaming discrimination, it stops the whole process in its place, and we determine and have an evaluation on whether or not there was a discrimination by a state actor or a state player. Because in 1990, that's what Congress found. It was state actors and state players, and the disabled will never be in a position of authority. And what I mean by that is look at how the LGB movement has really taken off, and I don't really care about it. God bless them. You know, you just don't have to shove it down my ass and shove it down my throat. I just don't have to accept it if I morally don't think it's correct. But I don't think you're any less of a human. I know it sounds nuts to say it that way, but how else do you say it? They don't bother me until it's being forced, like Connecticut's trying to do, saying right now, mass vaccination on everyone, even adults. Even adults, to go into any public entity, you got to be vaccinated. It's bullshit. But again, it comes down to now adopting new policies, providing documentation of compliancy, submitting to ongoing monitoring, demonstration of program accessibility, reports, and that's where we're getting them at, is demonstration of program accessibility. Report compliancy data to the DOJ. I give you examples of it, and again, here it is: United States Unified Judicial System of Pennsylvania, where the state judiciary agreed to adopt new policies and procedures to ensure compliancy with the ADA. Now, if you happen to be the golden one that lives in Pennsylvania, like my friend Tatiana, which I keep screaming at her to use it, I even think she's got age discrimination because she's an older woman trying to step up to the bat for taking care of her grandchild. I don't know about you guys, but I'm pushing 60. I wouldn't want to be chasing after a 2-year-old all day. Those days are kind of energetically out of me. How do you go riding a bike for hours on end or go play ball when you're hurt from head to toe? But it's again, there has to be a way. But again, when I'm talking about this stuff, it clearly says it right here: the state bears the burden to show the ADA and 504 compliancy. And guys, remember, 504 is your school systems, your health care. DCF runs on 504 money. Court evaluations run on 504 money. It would be, again, are you getting the appropriate needs? So if they're going to take your kids because you don't have a place to stay, it's bullshit. It's absolutely insanely bullshit. And again, that would be discrimination because it would be your disability that's stopping you from going out making that $200K a year like an attorney does, working for the state of Connecticut, doing nothing but 28 hours of work maybe, because half these idiots goof around all day anyways. And they always got some kind of place to go where they're going to have a big powwow and a nice luncheon and, the whole 9 yards and talk about nothing. Case law, Title II does not require intent. Guys, remember that. Does not require intent. It is an enforceable underneath a 1983. DOJ's appellate brief confirms proof of discrimination intent is not required to show Title II or Title 504 violations. Title II and Title 504 are enforced through private rights of actions. DOJ has the authority to intervene in cases to enforce Title II obligations. And you're right. Without sending your complaint and having an active complaint at the DOJ, this is why when I talk to people, I tell them, you got to CC everybody. I don't care if you think it's wrong to CC them, CC them anyways, because again, that person had the affirmative obligation to send you to the right person to handle your problems, your remedy. Impact. If intent is not required, then the only way the state can defend itself is by demonstration of actual compliancy. That's what Congress told them. You got to. The strengths in your arguments that you have, it's referring to some paperwork I gave it. It's referring to the 1983 enforceable right to demand proof of compliancy. I hold that right. You hold that right, guys. Once you've been discriminated against, it's already now discrimination. You not only have the right for injunctive relief to end the discrimination, then you have the right to ask, were you compliant yesterday? Are you compliant today? And will you be compliant tomorrow? Those are the three questions. You got to have a timeline. They cannot just continue to ignore this, or else it's underneath the False Claims Act. States must have an affirmation showing compliancy, not merely asserting it. Big time. So when they tell you to go to your Title I, and that's another document I gave Darren tonight, is to describe the difference between Title I and Title II. And again, so everybody stops getting this fucked up. When they send you to an ADA contact person, and that complaint form, because again, you're looking to make a complaint, an inquiry on why you didn't get a list of modifications for your disabilities, or it could be inquiring how to get accommodations in the building. It could be inquiring going back and forth about what your medical needs are. But first, once identified, they must just hand you over the pamphlet. And again, when I say hand you over the pamphlet, why? Because it should be already publicly printed and shown in public of appropriate modifications for that program, services, activities that the designated responsible employee with the advisory committee has found it to be an undue burden and an effective impact to the disabled's rights of that disability. So obviously, wheelchair ramps aren't going to apply to somebody who's got legs and that can climb stairs, but it might apply to somebody who's older and got arthritis in a broken leg or something like that, and they can't climb the flight of stairs. There's also distance requirements of walking. There's a lot to it, guys. Even rides, guys. I picked it up in this paperwork that I gave somebody. That again should be posted by the end of tonight on our CPS breaking website under equal and the same. Darren, is that where you're going to put it? How do these people find all this paperwork? Because I don't think we're going to have it up and going in time. Yo, Darren. All right. Remind me to ask him that question, guys. But where would they find it in the our
Yeah, we'll put it on the CPS Breaking News website, www.cpsbreakingnews.com.
Under the ADA section of equal and the same, or
yep, under that we'll put it right there. Yep.
Okay. Or maybe just put a hyperlink on the front page, make it easy for people. I don't know. I'm again not the guru, but again, this is where I continue to scream at everybody. Federal funding conditions state must prove compliancy to keep their funds. This is mandated, guys. This is not a joke. And again, it becomes now maintaining documentations. The DOJ 2018 memo confirms DOJ's authority to ensure consistency across all agencies. Again, the stuff that's going to be here tonight is going to blow your mind away. How does this support the federal removal? I asked it to question on how it is actually supporting my federal removal. Your removal theory is strengthened by the federal question of jurisdiction, Title II, 504, federal statutes. The DOJ has exclusive authority to interpret and enforce them. The state courts refuse to apply. And don't forget, guys, when you say DOJ is usually a state's attorney general. They have that same authority as the DOJ. So again, we're going to be looking at civil rights removals underneath 1443. We're going to look at federal funding conditions. They cannot provide I can't even say it. Compliance. I don't know why I'm getting so brain dead today. I've been at this shit since 7 o'clock this morning, guys. Be very patient with me. Federal courts must intervene. How does this support the 1983? I get into everything. Bottom line, you do have a affirmative right to demand proof of compliancy. And here you can argue that the states have an ongoing affirmative duty to demonstrate the ADA and 504 compliancy. Federal courts have an authority and an obligation. Federal courts have the authority and obligation to require proof of compliancy. You have a 1983, and that's another thing, guys, that I always put at the end of my complaints and my motions to any state court. On the very bottom, same caption head, number 14, demands for 28 CFR 35.107. Again, demands 28 CFR 35.107. That's a designated responsible employee. I want to file a complaint. I'm done. I'm not accepting. We hear when we talk about common law, some of these people talk about, statehood or whatever other theories. But it's when you do not refute them taking your right that it becomes, how can I say, a mooted point, because, again, the state courts have the authority and obligation to require proof of compliancy. Federal courts have an authority and obligation to require proof of compliancy. the feds look at it as, well, you never raised the question. Well, I'm telling you here, they have the affirmative responsibility. I've read too much case law where, again, the feds say, no, the disabled got it's all half backwards. But the point is, in 10 days, you can get a federal removal on your matters, end this bullshit, end the problems, and get federal oversight. And then start, again, I learned this from Gunner the other day, maybe even put a motion to put them on a Brady list if they're found guilty of abuse to people with disabilities. Through my documents, I was able to tie it in through the international human rights, because ADA was written by Congress in 1990. I believe the UN adopted it in 94 or 95. I'm not sure. And that's where they became the UN treatises for the UN World's Human Rights. I know it's complicated, but it all ties together, but hinges back to the ADA. And that's why the federal courts must look at international human rights laws. They have to. We just tied it all in. You cannot tell me the whole foundation was built off of our ADA compliancy mandates to end discrimination against disabled people, but yet the jurisdiction of the court, federal court, because you know how they love to do their own bullshit. And again, they've always neglected to accept international law. This is the only thing that, again, will tie you back into international human rights laws, guys. I know it's hard to believe, and until I can get this out to you, and again, you're just going to have to take my word for it and do your own research. But it's something for me to be able to have a talk. And I'm sorry I can't even see your questions, guys, right now. I will go later tonight and look through them. And again, so what it wanted me to do is draft an exact removal on my arguments here. And I said, no, I don't want to. And again, what's nice again about just guys, let you know, this is just free Copilot. This is free. You can ask these AI structures pretty much anything. You know, Darren's app, it's there. It's ready to be used. You want to get serious into it, then we'll get serious into it. But you know, this was just done by Copilot because why? I had it already trained. And from what I understand, everybody says, oh, you got to train it. Then other people say, bullshit, you don't have to train it. My feeling is when you use AI, and what I've noticed wrong about it is if you're not familiar with the law and the regulation or a concept of where you want to go with your own thoughts, that your AI will take you on a wild path and come up with some crazy shit. So again, whenever you guys are doing this, make sure you look up this stuff. And I know it sounds silly, but again, look at all the federal arguments I have underneath removal, structured for 28 USC 1331, 1334, 1330, 1367, 1441, 1443, 1. And I think there's a part to that 1441. And again, this is where sometimes the computer forgets shit. So I'm just saying to you, if you happen to see A, pay attention to A when you're looking it up and taking a glance at it. And this is nothing more that if you don't learn the argument, then on your toes, when you're in that freaking courtroom, you're not going to be able to dance like I'm dancing. And yes, it's taken me 15 years to learn this, but I'm giving you guys to the point where it took me to get these theories all worked out and all handled and all broken apart over the years. And you kept on scratching my head. Why is this not making sense? Why does everybody get to use ignorance of the law as an excuse? Trust me, I have it in here. They can't do that shit. So again, the federal jurisdiction is mandatory because the claims fall underneath the federal civil rights statutes and the federal funding conditions. These actions are removable 28 USC 1331 and 1441 because the core issues arise under the federal laws, including Title II of the American Disabilities Act, USC 12, 13-1-12-134. So there's a few numbers in there you want to read. It's mostly administrative duties. Anyways, Section 504 of the Rehabilitation Act, which again, the ADA pulls out of the enforcement of the Rehabilitation Act and a couple other, like the Civil Rights Act, USC 2000D, 24 USC 1390-83. There's also 85, and I believe 86 might be applicable. We're working that one out too. But yet, just is a quick computer giving it to me as a quick, I don't have to teach it shit. It basically, retains your story. Is it 100% retention of your story? No, but it has a pretty much good biomarkers from what I understand. Because what I did is I started up from Copilot today, and I asked it to give me notes in our talks as I launched another AI program today. So again, it was this, again, part 2, removal is proper underneath 1443-1 because the state courts is unable or unwilling to enforce federal civil rights rules. So again, guys, it's not hard. Once they deny and they don't answer you, that's unwilling, and you put it in writing. If I don't hear from you within 24 hours, because the information requested should be at your fingertips because it's published technical assistance for your program, service, or activity. So again, if you're having a hard time finding it, then how are we, the public, going to find it if the employees can't even find their own mandates? But again, state courts is unable or unwilling to enforce those rights. I have another argument too, where it doesn't bring it up, but how does the abuser get to self-monitor their own abuse? I just can't comprehend. And I think this is why the Congress made it where it was a DOJ fact, then became the state's ADA coordinator or the department's ADA coordinator. CHRO, your if they made the appropriate policy, it would be, I appeal from the town, school, I can go to the town board, I can go to the state administration, underneath their funding, either at the administration, legislative building, or judicial, because all 3 branches of government are supposed to have their own coordinators. Again, now would be a question, can I go to federal court or can I go to CHRO on this? I look for the path that's going to give me the fastest means to correct the situation of somebody with a disability being harmed, because it is harm when this person is unnecessarily struggling through life. And again, in program services and activities that can relieve that stress of the person with a disability, make them feel like they're whole again and part of a community process, and somebody actually gives a shit about us. The removing party has to assert the rights of Title II, 504. The court has to refuse to apply federal ADA or 504 standards, refuse to require states to refuse to require the state to demonstrate compliancy, refuse to provide reasonable modification, refuse to appoint counsel where required. Guys, that's huge. I mean, they can no longer do this under civil Gideon, run you down as a parent because you don't have the means of financial to keep up with the fight. I believe as an association right to somebody with a disability, and somebody wants to open up this can of worms and try to legally argue about the disability, I believe as you, the complainter, have that same process in administrative hearings or in a real courtroom to be represented by counsel at all times free of charge. Because again, we're trying to go after a complaint or an investigation against discrimination by a state actor or a state player, if that makes sense. We don't have to think hard about this stuff because the stuff was simple intent, simple language was used in the ADA. And again, you would want to use the test of Rachel versus Greenwood. So that's something that you guys can Google over there on your own end to see if you can find that. It should be a relatively familiar case law. If you don't have research tools, sometimes great information is Google Scholar. There's other, free apps out there that'll give you limited research. States have an affirmative obligation, ongoing duties is demonstrate the 504 compliancy. The failure to do so creates a federal question. So when they tell you to piss off, we're not going to give you my job description. Piss off. I'm an attorney. I don't have to give you any of it because I'm not your attorney. Well, wait a minute, Mr. Attorney. You're either representing the child or you're representing a fiduciary or you're representing the doctor. And all these people were subcontractors of the state. So how are you telling me you don't have an affirmative obligation? So again, you have the right to ensure counsel is competent in training in the rights of the ADA. And again, affirmation, ongoing, non-delegated issues, enforcement in the federal courts, period. This is where it has to go. Unless they have a policy or procedure that would allow you a faster speed than the filing of the complaint process. Because trust me, the federal courts are not making it easy on the amount of paperwork you have to do in the different certifications. Rule 17, you have to non-declare yourself as a non-entity business. You have to even know whether or not who you're going after is a entity business. It's fucked up. It's plain and simple fucked up. When this litigant challenges the compliancy, the burden shifts to the state to prove it. The state court shall the state court's refusal to require proof of compliancy itself is a federal violation, triggering federal jurisdiction. So what it's saying there is if I go into the court, hey, Judge Brown, you piece of shit motherfucker, I got DCF over here that's telling me to shove it up my ass. They're not going to make me have effective knowledge of my kid's medical education, the whole 9 yards. I can't even communicate with my children through via email or a virtual reality, which I think that's all bullshit. I think it's unnatural. It's not a natural freaking environment. I think you should be seeking a natural environment of the disabled's normal routines. That would be the best beneficial option to go for. Because again, it takes away their unnecessary, buildings that they have there where they're charging for these visits, and you have these stupid fucking games that are missing parts and bullshit like that. And, there's somebody behind an I Spy glass watching every movie. It's crazy. DOJ enforcement in the action, prevailing documentation, compliance. United States versus Unified Judicial System of Pennsylvania. So it's coming up again, guys. Compliancy question. The state must prove it. Title 4, 504. The federal courts must accept jurisdiction where the state courts refuse to apply any federal laws. This is great, guys. USC 28, 14, 43, 1 in the supremacy court proceedings, the Supreme Court proceedings. All courts refusal. Well, you do have the supremacy laws, and that's why I was getting confused there. I should say supremacy laws. All courts refusal to apply federal and civil right laws or refusal to provide a forum where federal rights can be vindicated. So remember how I was saying if they had a policy or procedure, we want you to go to the town manager on the schools, and then from the town manager or the mayor, you would go to a next level. So it'd be all part of their policies and procedures on who has it, because it starts at the person, entity that you are dealing with that has monetary control over the budget to autocorrect the system if discrimination is identified. I know it's a lot of words, but they're simple words and they're simple meaning. Federal court removal is also appropriate under 1441 because the case necessarily depends on federal law. Claims cannot be resolved without interpretation. Federal funding, federal supremacy principles. So that's huge. They cannot overcome this shit. Thus, the case arises under federal law. The federal removal is proper under 1446D and is in effect upon filing. So basically, some court states like mine, wanted to come up with this bullshit rule. It's a house rule. You got to get a 7-day fucking permission rule to fucking do a federal removal. The fuck I do? I got to ask for permission for you guys to sit, and this is where the feds are not even compliancy because they haven't shown the path and spelled out the path for the disabled to truly know their rights even at that level. So again, there's an argument that I got going in even into the federal courts. Before I even get there, I'm going to be questioning on why there isn't a spelled out path and on how we can properly ask the question of federal oversight and federal removal and federal take notice or refer to the DOJ or the state's attorney general or Doge department or whatever it might be you're requesting. Once the notice of removal is filed, the state court loses jurisdiction. Any further proceedings are void. Federal court must adjudicate the federal questions first. That's what it's about, bro. If you can get the big daddy on their backs and start slamming them, people start getting nervous because I'm going to be able to show you down the road, these sons of bitches, I remove their fucking immunity. I remove their immunity 100%. And it ain't me. I don't want to even say it that way because now I sound like other people that have big heads. The immunity is removed, and there is no entities talking about this because the ones that represent us are fellow bar members, and they're not going to let that happen to their friends because they won't be able to go to the hoorah parties afterwards. All their little cocktail parties they love to have. Again, guys, it's going to be some real powerful shit. I hope that so many of you guys could do. Anything I do in red, this is the computer now. Do you want to matching statement of facts section? Do you want a jurisdiction in a venue selection? Matching prayer relief? Do I want a memorandum of law? You guys all know any time you guys put in a motion, you got to have a memorandum of law in support of your motion. That's a big no-no if you don't do that. I'm into actually affidavits of truth, guys. I really think that's our golden ticket because if it's not refuted in 21 days and you state it on the paperwork, that it becomes a fact of the matter of the case. And from what I understand about law, notices, and if somebody could correct me, notices and affidavits cannot be mooted, cannot be ignored, cannot be tabled, cannot all this shit. It comes back to the founding fathers' principles. And I believe back in the old days, everything was about an affidavit of truth. You put your hand on the most holiest sacred Bible, and God, so help me God, strike you down if you are lying. But anyways, it asked me to a version tailored to my Pacific State Court procedural history. I didn't want that, guys. I wanted to get into here's a clean, neutral, litigation-ready statement of facts. I get into the statement of facts. It's incredible. Please read. Guys, I'm not going to go through this word for word. I just want to show you some key points to this. But the removing party also asserts the right to enforce 28 USC 1983, including the right to be free from discrimination by state actors and the right for equal access to judicial procedures. The state court did not adjudicate these federal rights. So I think, and again, it's going to have to be played with for the people who have old cases. Fraud upon the court. Well, if they're signing False Claims Act, they weren't compliant. You cannot find history for the compliancy of that year, meaning designated responsible employee, published technical assistance manuals, self-evaluations, transitioning plans, spelled out paths, procedural safeguards, a signature like they do in IEPs in education. You have to sign for your due process, that you acknowledge that you've been given a copy of your due process procedures, which this is what we're talking about when I say designated responsible employee. That is your due process right for administrative duties to have investigations and among other things. I only care about the investigations because that's the only thing that brings change, and ends the discrimination and auto corrects the system and remedies the problems for the person with a disability, takes their clock back to day one if it all started. That's it. There is no ifs, ands, or buts. There is no redos. All these bastards that discriminated against you the first time, I believe they go onto the Brady list. They should not be able to work with the disabled again. What else? So I get in through all this, and then I ask for it to say, okay, you want a more aggressive version, still factual, but more sharp on the state's failures. And again, of course, you know me, give me that aggressive one because you want to hit these bitches strong and you do not want to let up. Then I went into a statement of facts of aggression with a version the state must provide compliancy doctrine. This is the first time I heard about this today, guys, a compliancy doctrine. And I haven't had a chance to look it up, but I've been playing with legal maxims of the ADA. I've been playing with a couple other ideas to see what's actually out there and built, because I think it's not until now, the year of the computers, this whole AI stuff, that we're able to take it. Because you got to understand, ADA, we can get intent inside the American Rescue Plan. We can get intent in Obamacare. We can get intent through the Indian Welfare Act. We can get intent from LGBTQXRYZ fundings and intent. The ADA is beautiful. Whatever gives greater protection to the disabled, the state must modify their programs and services and activities to ensure that's the best modification for that disabled's rights to have program success. Guys, that's what it's about. Program success. So again, the state courts and respondents are public entities and recipients of the federal financing. Therefore, they're bound by the mandatory requirements of the ADA Title II, Section 504, and Title 4, including the obligations to maintain accessible programs to firmly demonstrate compliancy with federal laws as a conditional receiving federal funds. And again, they don't care about our individual discrimination. It feels good telling the story. Save that for friends and close relatives. And when we get into our shows that, I don't know, Sam hasn't been on in a while. I was going to say Healing with Sam. But again, Tiffany's got a pretty good ear for listening. Darren's got a real good ear. I don't know how he takes half the shit he takes from the horror stories, because he gets deep and dirty with knowing every little detail. It's depressing. It's just depressing, guys, on what we have to go through. And again, There's 12 reasons there. I'm not going to get into it all because I'm not even at the first 10% of this document right now. Statement of facts, maximum aggression version. So I went with three different issues here. And if you could tie this, I asked the computer if you could tie this into the False Claims Act, and then tie it into a possible RICO and the rights referred to DOJ, should say, but it doesn't. HHS, OCR, CMS, United States Doge Department, and any federal attorney, inspector general, Homeland Security, or for whatever other department you can find that a judge cannot ignore this scream for relief. Because obviously it's happened to me before. I know the path, so we have to build our shit extra strong. You just can't go in there half willy. I hear exactly what you want. I can provide a single document, legal, RICO. Why? Because those cross legal advice, diagnose of legal rights, conclusion of criminal conduct, instructions for litigants, which are all I cannot provide. But this is important. I can help understand the legal concepts. And again, federal rights and framework, statutes and regulations, the educational principles behind them. So that's what we're working off of when you're dealing with AI, unless it's a paid program, legal program that can get into it. But even them, they hold themselves non-liable for the errors it makes. I just wanted to show that this was intended as educational principles only. I can create I can education, absolutely. It's just, again, before I begin, I need one thing from you. Do you want a unified document? And I think I said, yeah. I asked them to put it all together. So it says, okay, I'm going to create a 20-page. This is where it's going to get interesting now, guys. 20 pages, unified, professional grade, civil rights, educational monograph that blends all your elements you're asking me, plus judicial tone, CFR citations, modifications, request analysis, and federal oversight structures, funding conditions, doctrine, FAC and RICO educational explanations, and the general narrative that mirrors your protocol history. Yeah, my protocol history. We've got some time together. I'd say the last couple of months have been really blowing up my brains on the whole ADA, because finally, I can ask somebody a legitimate question and then be explained to me in a legal, comprehensive, educational way, and then let me make the decision on where I want to morph this. And guys, if you go to the understandingtheada.com, again, understandingtheada.com, Gordon, what's his last name? He's a professor down in South Carolina or North Carolina. Really good website. I like the guy, his intellectual thoughts and everything, because he breaks apart cases. But now there was something I didn't have a chance to review it, but Title II is expanding. I believe they're expanding it to emotional distress. This is something that we have not been able to achieve for 35 years. So if you think you're going to go in there and go claim emotional distress, it ain't going to work. But I think now the tides are shifting. So again, please go to Understanding the ADA. It was posted a few days ago. It's a great website. Again, I believe it's Disability Justice is another great one. Judge Bazelon Center is another great one. Any ADA training center, there's 10 of them across the country. They have online training modules, They also have, archived legal seminars, which are the training modules, guys. Let's just face it. And again, because why? Congress in charge, DOJ, and the institution of community living sponsors this as a technical guidance and technical ongoing living, ever morphing disability right, because we cannot say it's set in stone this way. We know every day technologies are making it more accessible for so many people. It's not even funny. It's again, pretty soon we're going to have robots, taking care of the elderly and the babies for us. It's going to happen soon, guys. It's going to happen quick. It really will be a George Jetson world if the oligarchs really want it. I personally want to go back to the old days of 1776. Give me 5 acres of land or 100 acres of land and a chance at making it in life. I think those were the best days of life, when times were simple. We didn't need, a Lamborghini Bugatti to go get a gallon of milk. It just doesn't make sense to me. When there's so much more we can do as a society. But a generalized narrative that mirrors in my protocols, an educational explanation of the state must provide comprehensive compliancy doctrine, the educational view of the federal oversight agencies, educational of False Claims Act. So again, you can get into the education of the RICO. What can I do? It's asking me. Ready? Here's the beginning of the 20-page analysis, and I think it's a lot more. It's just incredible how much stuff is here, guys. And again, if you can see my slide bar, I'm still at the top. I mean, my God, by the end of this, once it gets out there, again, I use all statutes, all regulations, the purpose of the educational doctrine, again, educational document, sorry, not doctrine. I believe there is an educational doctrine, no. Background, law review style, context, history. Okay, so we get into a little bit about the history, the purpose, DOJ's role, Section 504 conditions, funding conditions doctrine. It gets back into this. Again, Title 4 with cross-cut with non-discriminatory obligations. So again, I'm really taking it deep, guys. The relevance of the disabled rights. Title VI is 6, right? Structure of enforces the principles that federal funding creates a federal obligation, and the states must provide compliancy when challenged. It's the whole key right there, guys. Remember, I said if you don't ask, you'll never get it. And again, the ultimate requirements behind the DOJ's, blinding the nature of the DOJ's regulations. DOJ regulations have the force of the federal law. They are binding on state courts, state agencies, local governments. What was that? Likely judicial ruling on the federal removal of that ADA. What's Darren saying? Come on in, Darren. I don't know why you're texting me. Likely ruling on the federal removal in Title II Masters. United States District Judge in the District of Connecticut would evaluate the notice removal underneath the strictest standard of 1443, the removal OCT removal case 2235, and the control and circuit precedents on the formulation possible outcome basis assumes removal. Okay, this is a long one. I think yes, I did. Under Younger Harris, yes, 1971. Um, anyways, come on into the show if you want to talk about your findings, Darren, as applied, because obviously, I gave the guru this and a couple other documents that I'm sure he went and slammed it through his system. And again, this is what it's all about, guys.
Brain
Checking.
pain. The brain pain.
You're bringing pain, bringing the hammer down.
Brain pain. You got to look through this stuff, right? No, this is what you asked me to do for you, man. This is what
Yep.
you.
Do you have a location where these people can find, or can you promise them by tomorrow morning they'll have it? Because I do believe there's a lot of people.
Let me see.
Who's this? Ree,
Yeah.
love me, Henry. Thank you, Ree. Tammy, I'm quite impressive. It's quite impressive. Tammy, I'm telling you, me and you are going to dance one day on this show. You've been here. You deserve to come up here if you want to get into this.
Hell yeah.
Where you get all your law from. Guys, I was taught by a gentleman, and I'm going to say his name. I don't really give a shit, but Bill Moretti out of Connecticut. And he was already, I think he's pushing about 75 now, maybe 78. But he spent his whole life from 1990 fighting for his kids in family court. And his son had disabilities, and nobody wanted to identify it. He lost everything. He lost everything because, again, back in those days, that was, when we were doing the turn from men were beating women. And I get that shit, Darren, in the 60s, but this ain't the 60s no more. And to give an upper, unrefutable situation to somebody is ridiculous. I think people need to prove their own abuse and neglect. They just cannot go in there and say allegations. Where again, this is where Tano's argument, and again, too much as that's being done. We're not able to actually defend from allegations in a civil court, especially when it's a criminal charge that has no business being in that.
That's right. You're guilty. You're guilty all the way. In the
They're going to hammer you just
right.
to shut you down and get rid of you.
Mm-hmm.
They don't even want to hear it. Oh, you got $100,000 for attorneys? We'll listen to you for about a year.
Yeah, but then also this though, Henry, why can they swap back and forth? They can use that against you in your criminal case, but not in the criminal case versus your civil case.
Right.
So
my question to you, son, is what was that you just texted me? You ran it through the whole system, and you're going to punish that with your analysis, correct?
That's what my system came up with for you. I asked it how would a judge rule in this system on this removal, and it gave me the answers to what it thought would be your.
And the audience is in suspense until they read, or am I in suspense until I read? Because I glanced at it quickly, so I'm tired of reading, guys. Unfortunately, we got to get this information. I've been saying it since August. I want to flood you guys with stuff. Darren should have enough technical guidance, case law, the whole 9 yards to start building something on our website so that, again, like Darren tonight, he was it was funny, guys. You guys got to understand this one. It is so funny. God damn it, I got to get my printer working. I need paper. I need paper. So again, that's all shows you how we all learn differently, guys. Darren needs to actually, and I'm the same way. I'm sorry, I can't envision the whole computer world. I like paper. I got paper everywhere.
Yeah, it's just I need to feel that I got to be able to. Pull out my highlighters and, I got to be able to do all this stuff. I can't just.
And again, that's how some people learn. And again, the courts have to take it into consideration. And again, what I hate the most is why they got you under a shotgun, right? And you're in sticker shock because you're trying to keep with the whole proceedings. They're mentioning things that you really need to have an affirmed knowledge about. And yet there is no way. So again, I believe that you should not be leaving that courtroom unless you have an absolute recording And guys, if you do have any type of memory, cognitive issues, or post traumatic stress where it becomes forgetful because you're in such a fear, they do make a thing called real time and CART. Those are two ADA acceptable formats where everything's put on a monitor for you to read. You can highlight. Well, one program gives you the option to highlight and to be able to cross examine people on what their statements were, and recall their statements relatively easy. And that's kind of where I like the blend of both, where the hard paper is great, but then I can't find that stupid document, and I'll go into my computer, and that's the only way
Sorry, I agree with you.
find it, is put in a couple keywords, and or like today I had to go to somebody's email to pick up something I wanted. And I'll tell you, it doesn't matter. Darren sent me a Black's Law Dictionary digital, and I wanted it for this new AI that was going to be doing today with Darren. And again, it's just, I don't know. It's crazy. I mean, again, don't leave it to just one. You got to have multiple sources.
Why wouldn't you, right? In this day and age of technology, and like, look at, you have the whole entire library, Black's Law library that I gave you, and it's, a click away. I mean, I miss my books. I had 4 or 5 of the Black's Law books. I don't have them anymore, man. That crushes me. But
with the Black Law, when it's a book form, I always put in, like you said, the highlight, or else those little sticky.
Yeah, dude, tons of those everywhere. The little notes sticking out of the tops.
Yeah, those little green note things. These stupid things right here.
Yeah, I got mine right here too. Yeah.
We're old school. Probably we got 20-year-olds calling us freaking old men.
Yeah.
But you know what? That's how we learn, guys. I was in the same shoes, listening to the older gentlemen and teaching me. And again, everything he said made sense. And when we were going to fight with the judges, and they were shutting us fucking down. Then it's a fight between us. I no longer have that problem because AI. And again, if you push AI too hard, guys, it will give you whatever answer or create an answer. So be very careful on what you're doing when you're dealing with this stuff.
Yeah, I mean, you just got to pay attention. Always just check. Go back and look again. Make sure that it's, make sure if it tells you the sources, check those sources, right? Like, it's all you get. It's very simple. Make sure, here's the other thing. Make sure when it's quoting case law that it's using the right context in the case law, because a lot of things that are coming up are people are using these things, and then the case law will come out and it's not meant to be used in the context that you're using it, because people are just skimming over what they have. You need to look at the case law. You have to understand what these things are, what they're, like how they've been affirmed, what's going on inside of these documents. Because if you put that in there and you're like, oh, this versus this is this, the judges are going to look at that and go, no, and dismiss your whole case, and then it's all done. All because you didn't pay attention to that,
Well, somebody told me the other day that their shit was so tight that the judge asked them, you got to tell the court if you're using legal AI. Again, guys, I go to understanding the ADA, and you're bringing this up right now, Tammy, that you have a disability. And again, because of a stroke, you got 25% of your voice. I'm sorry. This is just another adaptive tool. If the federal fucking government can use AI to run the government, run our military, run the building, how the fuck can we not keep track of everything, Your Honor? And again, it's based off of what I input to the computer, and I tell the computer and set the perimeters. And basically, this one document tonight that I made that we're reviewing was the fact of, for you guys to set the perimeters on any PC, including the Punisher. You want to throw it in there underneath your history and keep this as your prime directive. It's not going to know you want to do a federal removal. It's not going to know you want to do an 1983. It's not going to know you want to go for RICO. It's not going to want to know that you're going for false claims.
Henry, what are we gonna title this paperwork here?
I don't know. Let's call it the Mario Brothers hammer.
The Mario Brothers hammer.
Yeah, because you know why? Everybody plays ignorance about these laws.
Hey Google, what did they call Mario Brothers hammer? Was it just Mario Brothers hammer?
No, well, it's their hammer. I don't know. Don't they got a hammer in the old game?
The original 1981 Donkey Kong arcade game, the item is simply called the hammer. While often associated with the Mario Brothers today, it didn't have a specific brand name in its debut. In later titles like Super Mario Bros. 3, the power-up that allows Mario to throw them is called the Hammer Suit, turning him into Hammer Mario. Would you like to know about other classic power-ups from that era?
No.
No.
Yeah.
Can Henry be called Mario Brother Hammer and Hank?
If Henry's hammer, Henry's Mario and Hank hammer. Yeah, we can figure that out. If that's what we want to do. You want me to, that's what you want in your hammer? That's what you want in your hand now is the Mario hammer?
Hey, the Mario hammer, because it's going to be used against fucking people that want to fucking play ignorant. So you nail them with it. You set up your AI, you use it in a way that's going to allow you guys to go. And again, at the very end of the document, it gives another re-opinion. So now you're going to have 3 different AI opinions between Darren's opinion and the one that, I'll tell you, the co-pilot that created it, and the second one, which was, again, Darren's program again. So you're going to have 3 different ways of an opinion here that's going to, how can I say this? Confirm you're not nuts, and then you have to confirm it and put your hands on the actual statute and take a quick glance. Guys, it ain't about remembering it. You don't have to remember it. This is what it's all about, Tammy, that the AI is going to end up helping you in your day-to-day operations. It can, when you come home from a problem, you give it a quick note. It's going to remember this and build you guys a timeline. So again, this is what you want to do from day one of your case or your intervention or whatever you want to call it, engagement of the state. I don't care if it's going after benefits for your kids or yourself, or education or whatever aspect of life. It has to apply to any Title II entity. And they're subcontractors. Don't forget that, guys. They're subcontractors, have liabilities too. And so how are we going to get it there, my man? Make sure that you're including the memory.
I got it right on the front page. It's right on the front page right now of the CPS Breaking News website. So
it's on the front page. What about all the other ones? Because I gave examples of how you should write to the GAL, the judge, the court, how you should engage the designated responsible employee, or what you're going to be stonewall is with a contact.
We'll put them all we'll put them all in the Henry thing, but for right now I'm just trying to get them up here to
let people enjoy.
So I'm trying to get it up there. Boom. All right. So I have the first one and the second one in there. I have your I don't know, go to let me see, make sure it's all should be all updated here. Website post. Yeah, go to www.cpsbreakingnews.com.
Can you put a hyperlink in the chat box for our peeps?
Sure.
Tammy, you're only 58, babe, and you had oh man, I'm sorry to hear. Well, life ain't over, babe. I would be looking at a naturopath and going to see a naturopath and changing your eating habits. Get up on your vitamins. We talked about this earlier. I caught a data the other day that the United States or the American Cancer Association has known cancer is from a with a parasite. A parasite is creating this problem in our bodies, and yet they have not addressed this parasite issue. And I think me and Darren talked about it. What happened to the Incas? What happened to the Mayans? What happened to all these great civilizations where one day they're gone by disease? And again, we don't know what the parasite is.
Yeah, man, I don't know, because like, where did they go? Like, where did they go?
The Roman Empire. How did that many people disappear overnight? How do you just abandon a place like that? Even to say that if the whole town left, that means I got free open gain. I'd be tearing apart buildings to make myself one big beautiful building.
Yeah.
All right. So what's that? Google Docs?
No, that's where one of the things are actually uploaded. It's where it's listed here. This is the yeah.
Did Gunner throw that in there? Because Gunner got a copy of that early this afternoon too. And again, I'm gonna hammer on Gunner now, because again, Gunner, I love the brother, but he wants to continue to fight with these people. Where I'm trying to say, it all ends in 10 days. 10 days. That's all these motherfuckers have to answer you. Why do I say 10 days? Because on 90% of the ADA complaint forms or request forms, you have to give them a 10-day notice. Bullshit. I have a fundamental right to walk into my town hall. I have a fundamental right to walk into an educational program anytime to see and integrate with my child. I have a fundamental right to walk into the courts at any given time, to even listen, to be a spectator, or go to court services, or go to, which I consider a big one, is the law libraries, guys.
Mhm.
It's got to change. We got to have online accessibility at
Yeah,
home.
we have that on our CPS Punisher app. There's a law library on there.
Yeah, but with like the state of Connecticut wants you to use their quotations and their reference numbers. They don't want external. They don't want external resources. So what we do is, because again, I don't know how to make a hyperlink in a brief, but that's another thing I asked for a modification for in my technical filings, that they can't hold me to a standard, because again, technology is a disability for me, guys. And I don't know, but yeah. So I'm a hammer on Gunner. He's loving it that he's got AG's office. I say fuck it. The AG's got to give you a designated responsible employee of their department, and again, their affirmative obligations. I want their non-discriminatory training, and then again, if they don't answer in 10 days, then this is going to get Papa Bear to squeeze the nuts of lower brother. It's a tool technique, guys. It's to get federal involvement and federal oversight, and most of all is to correct the program, services, and activities immediately to end the discrimination before harm cannot be undone. And again, there's harms out there. I'm sorry, guys. There is no financial win for you. There is none. I just don't get it. These kids have got to grow up in the system. And oh, well, we'll give them a couple of $1 million. They were raped and abused all their life. You really think they're going to be fucking normal? $2 million is going to do what?
Yeah, right.
The government's got you as something like $14.3 million capability of earning bonds and in trusts and in other, money managements that they use on your ass for just being alive and breathing. It just doesn't make sense to me, bro. I don't know. Has anyone had a chance to go see what Darren did for hard work and put it up there? Come on, somebody give me a thumbs up. Give me thumbs up. You got to be listening. Listening and watching, multitasking. Gunner doesn't even give me thumbs up, that bastard.
He's too cool for school, man.
Well, we're going to have to slap his ass around tomorrow night a little bit then. I'll go in there and take over his show. If he don't want to talk now and be a big boy, because this is applying to him. And again, it's applying to all of us, because I haven't seen one state that's compliant. Truly compliant. Don't get me wrong, some of them have made some awesome strides, but be 100% compliant is the only civil right, because again, the disabled are never in a position of power. That's Congress's findings from 1990, that they have make this as an affirmative obligation against the states with prophylactic protections and strict scrutiny. Darren loves those words. I'm telling you, it's a solid affirmative obligation. There is no higher standard. And again, criminals are clear and convincing. For death, it ain't strictest scrutiny and in prophylactic protections. It just, there is no higher standard of law. Well, hello, Gunner. You gonna come on? You gonna talk to me tonight or what? Eating again. You freaking, that's what you get for eating sushi with freaking, he's over there eating sushi today. And I'm telling him, dude, you don't want to be eating raw fish. You know, they got all kinds of microorganisms in there and freaking parasites that we were just talking about.
God.
You know, there is no such thing as fresh fish anymore or unpolluted fish.
Mm.
Even pork and beef and chicken. The Amish got it going on, brother. That's all I'm going to say.
Yeah, canned vegetables sounds just fine to me, man.
Yeah, well, even our lands, like I was saying to Gunner today, you know, at my house, you know, because my grandpa grew tobacco, I'm dealing with tobacco sprays. But I don't think it was as bad as what you got today for chemicals for the blue mold that they use on tobacco.
Yep.
Because I'm right here in the Connecticut Valley, we're considered the wrappers of cigars, the broadleaf tobacco that was the original money crop of the country. So,
yeah.
What else we got? Any good news on your end?
No, I don't have a lot of good news tonight, Henry.
No.
No. Just the app's up and running and it's doing pretty good. If you guys want to check that out, check it out. That'd be great. What else we got, Henry?
Well, how you making out with your legal fights with these cocksuckers?
They're still locking us out, man. We're still closed out of that place. So I filed some. I did some things. I don't want to talk about it right here, but
right.
I mean, I did get.
Okay, Henry, I'm here. What do you
All
got?
right. You gonna show us your face, your pretty face too? Because that's another thing I hate in life.
Well, you hate and laugh. I'm trying to figure out. I'm on the mobile version. There you go.
There we go. Gunner
What,
finally came into the show.
Here he is.
We're going to piss off today.
So did you get time to read? Because you've had the document now for hours.
I've got a couple of those things done. We had to take care of a couple other things here around the house that we had to take care of. So I was just getting settled back in with stuff and getting ready to go over it for the night. But our Rule 60, for people that want those updates, we filed a Rule 60, 60.02, Rule 60.05. Rule 60.02 is for extringent fraud. Rule 60.05 is extenuating circumstances. So if you go beyond your time limits or some of those other different things where it's just that extravagant for you must be heard, you file these appropriately. Now, one of the things we filed, and with every motion, remember, guys, when you're filing your motions, make sure you're filing your memorandums of law. Why? Because then the court has to address the law you've quoted in the memorandums to defend your argument or your motions. Make sure that that's in there. But we did it under the, I'm trying to think of the name of it. Maybe Darren can help me out with some of this, but it's like constitutional questions doctrine. Or general questions. Either it's a questions doctrine. I can't remember the name of it. I don't have it in front of me. But what that does is it escalates your case of saying there are questions that the lower court does not have the authority or power to answer these questions that are arisen within this case or the things that are brought up. So it automatically goes to your attorney general. Your attorney general and their team, they begin to do that. Now, if they can't answer it, that then forces your state attorney general to file with the federal court on especially federal questions to go to a 1983 and then ask a federal judge, hey, what is the ruling? We have a question. This is what we need an answer for and how it pertains. And then they write it, file it, and then they have to follow what the federal court does down to the attorney general and then go down. But once again, I think it's called General Questions Doctrine, Darren. Is that what it's called?
No, it's the Constitutional Questions Doctrine, I believe.
Questions Doctrine. Yeah, okay. I knew it was there. So now this can pertain to both your state's constitution or the federal constitution. Now, your attorney general is basically the person that will say, this is the interpretation of our state constitution. And they are the only authority or the highest authority that can answer the question, because the lower court cannot answer those questions, nor are they allowed to interpret those things. So you're tying the lower court's hands of saying, you must answer these questions before we proceed, whether it's federal questions and or state questions, and you have to form that document appropriately to basically say, quit with this business as usual stuff, crack open the fucking book and do your fucking job. You know, let's get some real answers, and you're going to stand by them. And if we don't agree with them, once again, we can move forward. But once again, then you go through the procedures, what it's supposed to go. But there a lot of people are not using, and I think this is something we discovered too. We've talked a lot about void ab initios, even with ADA or anything else. Hey, you're not giving my ADA. That's a due process violation. Now we're void ab initio on top of the other stuff. That's what the Rule 60s are. Now every state's got something different, but like a lot of states like Tennessee, Kentucky, so on and so forth, follow these same rules of civil procedure. This is also the federal rules of civil procedure under a Rule 60. So this is something a lot of lawyers don't deal with.
Which the state, when you're talking about this stuff, people got to understand the state can increase the level, but the federal bar is set here. And that's where your state constitution could be giving you more. It can't give you less. It can give you more protection. Correct. So that's why he's telling you guys to watch both sides of the nut.
Yeah. And if you're going to quote the Constitution, the U.S. Constitution, the loophole that a lot of people don't do to close that hole is you have to quote your own state's constitution, referring back to the Supremacy Clause Constitution that is in every state constitution to say, hey, you must follow the federal constitution. Why? It says it in your own state's constitution, because otherwise they're going to argue we don't have jurisdiction over that, or the state doesn't. Yeah, but you do over your own state's constitution, and it mimics this, or it says you must follow those federal things. Why? Because it says it right here in your own constitution. If you fail to put that in there, it kind of gives them a loophole that they jump through, and they always take that loophole of saying, well, we don't have to deal with that, or we don't deal with federal issues. Well, hold on. Yes, you do, because I have specifically said this is what you must do. And once again, this is where a lot of things, and I guess one of my questions that comes with these judges and magistrates is, you're the one sitting up there that's supposed to know the law. Why am I reminding you of your job or doing your paperwork?
Oath to the Constitution, and then an oath to protect us as we are the defendants.
Correct. But the ADAs, yes, you have those opportunities, and once again, I think Henry a little bit. Once again, it wasn't my case. My case has been closed. Yes, I'm at this particular letter, and then we filed the Rule 60 under them. The ADAs.
Your case is the absolute right case to be trying the fraud aspect. The fraud aspect is solid. Were they compliant back in the years that they took you and harassed you, or were they not? You know what I mean?
No, they were. Matter of fact, when they found out it was me, the court clerk actually on all documents now, when they do stuff or serve them, they stamp it right on there for ADA, for any ADA issues. Call this number or here. In other words, saying it is automatically readily available, because we have raised a hell of a stink here in Blount County to where now they've had to create a stamp, and they say, make sure you stamp that document. Make sure that if they need ADA, all they have to do is call this number, and we'll make sure they're accommodated.
He's in Tennessee versus Lane. He is the king of my world. And I'm surprised on how bad they're able to figure out how to still screw us. My arguments are when they're so blatantly obvious, the deception that the government has created around these rights. And again, all because they do not want to modify their Holy Grail practice book rules and regulations. They don't want to modify them, period. They don't want the cost. They don't want the burden. They want to push these cases through. They don't give a shit. It's going to be, we know what's best for you, and fuck off.
Well, and Henry, let's go over one thing. For example, one ADA issue is if I have to have a real-time person in the courtroom typing so I can see on the screen. Do you know what the cost for that ADA service?
About 3,500 to $4,000 a day up in Connecticut, and whether they're there for an hour or they're there all day, it don't matter.
Listen, do you know how much that cuts into their cost of operating another day in court, another day of court? Because that person has to be there every single day for this and that. That gets into what's called their profit margins.
Right.
You're now cutting into them, and now it's not profitable to
I
go after you.
call it their bonus money, because without their bonus money, to go start paying all these dividends to judges and attorneys and GALs and the whole AFCC kickback scheme that Connecticut exposed in 2016. That was a great person, Susan Skip, just awesome person. She really took it to the hill, but even that we got fucked. Guys, they don't want it. And I was hoping Trumpy was going to be the one. Now this goddamn war is shoving it up all our asses right now. And yet, I don't know.
Listen, we have, and a lot of people don't know this, we have the world's largest oil reserve sitting under the Colorado Rockies, larger than all the others combined.
I believe it.
If we would just get in there because of some, and the concept was the long game, was my understanding, was to dry up everybody else's reserve, and then basically America becomes the next Saudi Arabia. And we have so much money. Why? Because we have such a vast supply. If we would just tap back into that, we would see gas prices probably under $1. I mean, to be all honest, and let alone our own refining and everything else, because we have the capability of doing that all here for our own people. The problem is they have removed the drilling rights or the fracking rights from those people to get at those reserves that would help the American economy so much. That we wouldn't have to worry about it for, I don't know what the last estimate was of how many lifetimes of Americans, even if we held on to everything and never sold a damn thing, we would be set for, I don't know how many generations. I think it was like, 89 generations, compared off. And that's not even including any other technological advancements, so on and so forth.
Which we are going to make technological advancements in not only solar, and other types of energy propulsion systems. And again,
listen, as a master electrician, I can tell you one of the things, if we really wanted to, we could, is earth magnet driven motors. Yep. There's no waste. There's no consumption. It's clean energy. It's fully sustainable. And why we don't use these, we could power our homes for nothing and just let it run.
Right.
But once again, there's no profit margin. There would be no reason for the Department of Energy to be involved in residential, let alone small businesses, if these machines, which are very efficient to build, I mean, a standby home generator system cost, I think, is anywhere between $4,000 and $7,000 the last time I checked. And take out the drive motor, which is based off of propane or gasoline or natural gas or some of these other ones that different ones.
Magnetism that
it just runs. It just runs, baby, all day long. Free energy.
Yep. It's
and like here's the thing:
motors, man. They were so gas efficient because again they had the kinetic energy behind the big flywheels to keep them going. So, again. Magnets.
Well, now let's adapt that.
Magnets, man.
Let's adapt that technology. Put that same technology in electric cars. There's no need to recharge. There's no need to do this or that. And it's as simple as, and this is the basic theories of magnetism: opposites attract and same poles repel. So you angle them, you spin it. How do you turn the car off? You just pull the magnets far enough away to where the motor doesn't run. You still use a transmission. How do you start it up? How do you accelerate? Push it in, or you get it to a specific, obviously it's all computer controlled you can do. But once again, we're already doing this stuff with motor control theory, which are the big motors that turn with stuff with programmable logic controllers. and a lot of those other systems. So why don't we do this? Because it would shut down the oil industry, or a need for it other than lubrication.
Right.
There's no need for it because then it's clean and nobody makes money. I mean, imagine every American not having a fuel bill, an electric bill,
Right.
or gas, or fuel, or anything like that for your car, or anything but just lubrication. Now, what are you doing? Yeah, I'm hanging out with Henry. He's on for a second. Yeah.
Yeah. All right. Let's get out. We're getting way off bases though for tonight, guys. I think we had a good productive session here, and I don't know, Darren, you got us up and going. I thank you. I'm asking everybody to go to the website. It's right there on the front page. You should have everything you need to start engaging, because this is what we got to do. And I think this is how we can get Trump's attention, is to show the fraud in all these Title IV funding, 4D, 4E, ADA, all these state programs, services, and activities that are just purposely defrauding the federal government of the purpose of their grant money. And I think that's a better claim than us trying to prove individual discrimination. Because let's
rephrase that, Henry. Not just federal money. That's our money. We the people's money. It's not the federal. It's all of our money.
Right.
I mean, it comes down to it. But guys, I'm going to check out one quick plug tomorrow night, 9:30 Eastern Standard Time, Gunning for CPS, right here on YouTube. And several other platforms that we basically go on YouTube under the Gunning for the number 4 CPS at 9:30 p.m. Eastern Standard Time. Guys, I'm going to check out. Have a great evening, Henry. Keep doing what you're doing, brother. Plugging away.
All right. Well, you keep it up with your family and tell them we said hello, and get on that shit, because man, I'm sorry. I would be sending that Attorney General a real affirmative note saying, listen, I'm also raising the facts. Were you compliant? And if you weren't, it was fraud upon me. And isn't this picking fruit from a poisonous tree doctrine?
Fruit from a poisonous tree doctrine. Yeah. Well, we've got some other things coming, but
because again, you're going after the AG now for false claims because they certified that the state was compliant.
Right. So keep fighting, keep going, guys. Education, knowledge is power. Once again, we're all learning as we go. This is how we take and we learn. We share information. This is how this works. Once again, but remember, no two cases are the same, and you have to apply it according to your own personal case. Out.
Absolutely. Enjoy it, man. Thanks for coming in. So what do you think there? I can't hear you, Darren. You got yourself muted.
So I put it up here. I put your information up here. It's right on the front page of CPS Breaking News. Okay. Along with a bunch of other stuff. But yeah, your stuff's right here, top of the page, dead center, Henry. As seen, unequal, and the same, it says.
Okay, beautiful.
Download for that is right there, dude. So you can download it. You can download that 162-page document that you have if you'd like.
Mm-hmm. That ended up being 162 pages. Are you shitting me?
I won't shoot you, Henry. You're my favorite turd.
Fuck me. I didn't think I was that good.
Yeah, you are.
But again, the point of it all, guys, is to create it so you can upload it to your AI systems or however you're using. But you got to understand the basic principles, and this is the basic principles as best I can understand it and interpret as an educational purpose only. You got to confirm all our cases. I even went as far as giving us jurisdiction, and I know you guys are going to love it. It's called Bodie. I broke it down out of Bodie, 1971 Connecticut civil rights case. That's a very strong. And just to let you know, the state of Washington ADA committee centered their whole policies and procedures around the Bodie case of Connecticut. How can I confirm it? Go to their website. Look at their technical assistance. It's up there.
Mm-hmm.
They got a pretty good technical assistance manual where, again, it gives me a fair shot. And that's all I've ever asked for from the courts is a due process right to have a fair shot to be heard. And again, that's what our whole purpose is here is to, again, to educate, not to humiliate, because your disability should not be the forefront of the cases. I'm going to say it, the judge's lips. That should be the last thing on a judge's lips, or a CPS, or a DCF person. Um, so again, guys, learn your rights. Gunner was right. Knowledge is king. It's going to get you into more trouble in the beginning, but I think in the long run, if we can develop this plan across the country, that we'd be able to include it and incorporate it as another argument that everyone else is doing. And I wish, Jessica would come on one night, Lewis, we can have a good conversation. Tanawa, Connie, anyone that's legit. I mean, seriously. And guys, by the way, too, my paperwork right there, Francesca Amata gave me 2-3 pages of information for $3,000. So consider this your freaking Christmas bonus from me to you. That's the way I look at things in life, Darren.
Mm-hmm. You know, baby.
162 pages. So I would have had to pay Francesca or schmucks like her. That again, I was in a meeting one night. And she said, "Oh, you shouldn't be advocating for your own ADA rights. Are you that stupid? It was written for the fucking fact of the disabled to advocate for themselves."
Mm-hmm.
So this is where you guys got to pick it up, guys. It's not to save all, but it's another way to squeeze and spin the table on these bastards, on another violation of your due process rights. And I think it's the strongest argument out there, because why? Congress doesn't fund for parents' rights. Congress doesn't fund for you to be a good parent, a bad parent, or an indifferent. But Congress does fund to ensure a level playing field for the disabled. With effective communication and effective access. That's all I can say, my brother.
That's it, Henry. That's what you got for tonight.
That's it. I mean, I don't know, Tammy, you're rocking tonight, babe. You should have came in, bullshitted with us. I know you're saying that you had a stroke, but we give accommodations here. We give a modification. It's all about, brother. I don't know. Take us home. Bring me backstage. Let's powwow. And thank you guys again. Until next week, same time, same channel. I'm hoping Monday night, Tuesday, we can have an emergency update and have something really gorgeous for you guys to look at, that I have no problems with putting my name on this document. Thanks for coming in tonight, guys. Enjoy. Hopefully.
Not sure how long they can pursue their hope sheerly stripped away, facing challenges each day, little by little.
Good night, everyone. Hopefully we have a great week, and hopefully I'll be swimming soon in a pool like that. I don't got one. I got one of the big blow-up pools over at the big blue pools. Love it. Knock it down, put it up.
We drop to our knees in prayer, begging, let us fight despair. Let my heart fight one more round. They cannot take what I found. Little by little, shall rise up and turn the page. My words will guide your brave stage. Go and spread your message true. Now's not the time to bid adieu. We are all broken inside. Doesn't mean you say goodbye. He has given you the might. Show the world your inner light. Little by little, they kidnap our children's play, chase their fathers far away, tear families with no pride, forcing you to run and hide. The corruption thick and rot, churches hold nothing not. If we stand up hand in hand, together stronger we stand. Cast out demons, turn away, embrace faith in Him each day, proclaim and guide your it's not late. Embrace him with love, no hate, for your heart will surely mend. He'll be your guide and your friend. Hope must remain in our fire. Hold us up to light so bright. Know he has you on his mind. You are now among the divine. Please God, hear this last plea. Wipe the tears away from me. I lead my children safe back home. There's too much left to alone. Little by little, point me to the right curve now. I wish I had you all along. It's never too late to commit. Just trust in him, little by little.
Imagine being a child who has been torn away from their security blanket, their parents, the ones who stop the boogeyman from terrorizing the nights and curing their boo-boos when they scrape their knees. Now just imagine how they mightest feel when the CPS meant to protect them tears them away from their supposed abusers and places them with strangers who have zero comforting skills. They need to be calm. They are confused, lost, panicked, and needing their parents, but CPS took them away for the purpose of saving them. The kids don't even know why, and they are told that the parents they attach to no longer want them. What do you think that does? Do you think that this is how protecting children is supposed to look?